All right.
Well, hello everyone. If you guys can see us, just put a hello in the chat. That would be great. Perfect. We have Daniel here with us today. He
All
is
right.
an immigration attorney from Larson Legal. He leads the team at Larson Legal. It's his own company, and he has been dealing with cases of H1-B, O1 visas, NIWs, EB1, EB2s, all of those good things. And he's going to be taking us throughout the entire new proclamation, what it means, what was the actual order that was signed, how did it change, and all about that. And to folks who are joining us from Instagram, please make sure that you also join in on YouTube because we won't be able to read your comments on Instagram. It would be better if you could post whatever questions that you have on YouTube directly. I'm going to hand it over to Daniel. Daniel, do you want to give a quick introduction and also what the proclamation actually meant?
Yes. Hi, my name is Daniel Larson. I am the owner and founder of Larson Legal. I specialize in mostly self-sponsored cases for artists, scientists, IT professionals, and professionals of all likes. A lot of my clients are on H1B status here in the United States, and I file and deal with the status each and every day. As an immigration attorney, on Friday afternoon, the Trump administration uh, announced a proclamation that they would be charging 100K paid by employers for all visa for people on H1B. And what the proclamation, it would come in, it's already come into to play, but it was announced to be on September 21st at 12:01 a.m. And basically, it was a visa. It's a travel ban on people entering the United States with an H-1B visa unless they paid 100. Their employer paid 100,000 to the U.S. government for this. The legality of the proclamation itself, I view it as grandstanding by the Trump administration that they have had experience with travel bans before that have been upheld, like in Trump versus Hawaii case. And they have a lot of experience. The Trump administration, the team has tons and tons of experience litigating these issues now, and they are trying something new. We've never seen this before, but imposing this whatever it is, this $100,000 fee that's supposed to be charged by the employers for entry. So, um, as you can imagine, this caused massive pandemonium between my client base. I maybe a good half of the clients I have are on H-1B status here in the US. And on any given day, I do not know where they are. They often travel in and out of the US. And so when the news of that this came in, I immediately started calling my clients to tell them, if you can stay here, please do. Please do not leave the US, because on Friday, we had no idea who it appeared the ban actually applied to people who had valid H-1B visas from previously approved petitions, and if they were outside the U.S., come on, after Sunday, they could not enter. That's not the case, but the text of the proclamation is quite broad or confusing on this matter, and the safest reading of it is that it applied to people who had a visa on it. We did not get clarification about this until Saturday, midday Saturday. The Trump administration on a tweet, said, like lawyers are putting out fake news about
Yeah.
the cases. Um, and there's all this for major employers all over the United States that have H-1B employees. You could imagine that people were just unbelievably scared. there's all sorts of stories about, oh, I was just on the plane, but then I got off, or like I paid all my money to get out of to get back. And this chaos that was initiated from this proclamation really is quite remarkable. I haven't seen anything like it. It
All right.
destroyed my inbox. How would I say?
Yeah. Yeah, no, thank you for that rundown. We have a bunch of questions already come in on our YouTube. I'll just post them up one by one. But
Sure.
people who are just joining in, either on Instagram or on YouTube, please make sure you go to YouTube and post your question so we can directly put it up on screen and ask Daniel those questions directly. I'll just take it up one by one. So the first question is, hello, my question is, I'm currently on F1 OPT and will be taking part in the upcoming 2026 lottery. Will this impact me and how?
It's up to we're not actually so sure about this. They said that this will apply to the new lottery applicants now, but here's the thing: you are inside the United States on OPT. OPT is F1 status. You have not left the US. And if you just read by the proclamation, it would seem that like this does not apply to people who are validly here on another status and then change status from F1 to H1-B. It applies when you leave and you try to pick up your visa. So today, it is very hard for me to say if this will affect your the lottery down the road.
Got it. No,
Your petition down the road. I think that like if you stayed here in the U.S., you are not subject to this fee. Like your case, your employer is not subject to this fee.
yeah, no, that was a
When
very similar thing that we heard at our organization and our lawyers mentioned. It was mentioned that the change of status actually won't be impacted, and the people who are actually coming in from the outside, applying from the outside, they would be impacted the most, and not people who are already in the US. But yeah, that's all up in the air, as you mentioned right now. Okay, next
hello.
question. Uh, yes, Daniel, we lost you for a minute back there, but we can hear you now. Perfect. The next question that we have is, hi, could you please let us know if I am on F1 STEM OPT, will I be able to travel next month and return back safely? What are the different things that I should keep in mind? Oh, we lost him again. Just give us a second, guys. Um, I'll add Deshna for a minute here. Deshna is also on Daniel's team. She works with him closely. She is an associate at Larson Legal, and she's a senior associate, and she can answer all the questions that Daniel can as well. So, Deshna, the next question that we got was, could you please let us know if I am on F1 STEM OPT or F1 OPT for that matter, will I be able to travel next month and return back safely? And what are some things that I should keep in mind?
Yes, talking about the F1, if you're on a STEM OPT, it should all work well with you. Make sure you have your I-20 with you. And also, there have been issues about the signatures on your I-20. So make sure you talk to your DSO and have a conversation with your international office at your university. But make sure that the signature on the I-20 is current. Otherwise, if you're on an F1 STEM OPT, it should not be a problem at all. You can come back safely, but just have your I-20 and the signatures from your college that down there.
Got it. When you mentioned DSO, what exactly is a DSO? Like, could you explain a bit more on that as well?
Sure, it is the designated officer in the international office of your particular university. So when we first get the I-20, initially when you are in your home country, you get your admissions and you provide all of your financial documents and everything is sorted. You get your I-20. When you look at I think at the end of the I-20, we have the signature right there from the international officer at your university. That designated international officer at your university would be the DSO for you. It might differ on a different I-20, so that should not be a problem. Just consult I believe that every international student right now, or anybody who's on their STEM OPT or OPT who have their I-20s, should just make sure that the signatures there are valid. Sometimes that signature might be valid for 6 months. It just differs based on the university guidelines.
Got it. Perfect. Thank you so much for the detailed breakdown. That kind of makes sense because I myself am planning to go back next month back to India, visit my family for a while. And that was a very similar advisory like that everyone is giving on the internet, even after reading it. So yeah, the next question is by Sprihanjay Banik. What should a student graduating in December 2025 do since they fall in the next H1B cycle? Should I rather work in OPT without sponsorship and try for the O1 route, or should I even aim for H1B?
I think aiming for H1B right now is not an issue because honestly speaking, nobody is clear about where this proclamation is going and what route is it going. As of now, it is unclear whether it applies to anybody who just does the change of status from F1 to the H1B. So it is not it H1B is not completely dead as of now, as of today, as while we are speaking. I think just take the benefit of the OPT that we all have right now. You can continue working on OPT, and it is always better to have other options open because it is not only that H1B will, if you might not get picked up in the lottery, what about that? So having an O1 route or just thinking about plan B is always better.
Perfect. Thank you so much for chiming in there, Deshna.
Thank you, Jason.
Daniel is also back.
Yes.
Uh, Okay, I think this is another repeated question, but how does it impact F1 OPT students? Like, what does it actually do? And a follow-up question on this is something that I have as well, is if I'm on OPT right now, will in the US, will it charge me $100,000 or my employer $100,000 in order to file that petition? And when would it charge? Would it charge during the stamping or even when they apply me for the lottery?
So, in terms of this question, it would apply during the stamping. This is assuming that this is upheld in the courts, which is, I think, is a very big if. There's lots of stakeholders in this process that are going to challenge this, and the challenges are being created right now. And so you'll have to see that. But if you're on OPT, I think that I actually think that the H1B program will exist as it did last week. Probably next lottery things. I think that the court, you should assume that you can go back. You can go on H1B come this lottery, and that this will be correctly challenged in the courts. I think that having a backup plan would be prudent, of course, but
Yeah.
we'll have to see.
Got it. And we have a question on that as well, like challenging it in federal court. Like how is it going to be challenged? What do you think are the possible scenarios in which people could challenge this? And what would be the outcome that we can speculate right now?
Well, already immigration lawyers were taking, I'm not involved in the litigation, but on the email listservs for immigration attorneys, they're asking us to, if we have known clients, stakeholders who in the H1B system, you can imagine there's lots and lots of interested parties, like university systems, like hospitals, like, people that they could not the companies cannot afford to pay this 100K fee, it's inconceivable. So we're gathering clients now to submit to say, maybe, hey, company, maybe you should join this lawsuit against this inaction. And there's thousands and thousands of potential stakeholders at play. So I think that probably as a general matter, like the big employers, they're going to be involved in this. There's, all across America, there's employers that use H1B, and if they have a sizable chunk, I think they'll, it's to their interest to get involved in this litigation.
Perfect. The next question we have is, my sister wants to travel soon to Ireland. Is it advisable to do so right now? As I had seen another post saying that this 100,000 fee is only for new H1B applications.
So if she has already a previously approved H1B petition here in the United States, and then if she has a visa, she should go ahead and she can use that visa to travel to Ireland as it's written now. I will not tell people to not go at this time if you have a visa. If you don't have a visa, you're going to have to get one. And at that point, that's a different story. But I think like this trip to Ireland, it sounds perfectly reasonable to do.
Perfect. And this is an interesting question about if my company already applied for me in the 2025 lottery, but I did not get picked up. And if my company applies again in 2026, will this fee apply to me?
Well, yes. If it survives the challenges, the entry into the 2025 lottery does not for like it's only if you were selected and then you initiated H1B status would you have be in the pool of people who already have H1Bs. If the 2026 lottery comes into play, it is your name is entered into it, you are liable. You might have to, your employer might have to pay this fee. Yeah. I just
Got
want to point out, just for your listeners to know, we've had clients who have valid H1B visas, have entered the U.S. without any problems, smooth sailing since this proclamation has come into play, and this CBP has honored their H1B visas. They were able to travel here and return successfully to the United States.
Got it. Thanks for adding that in. So the person who asked this particular question also followed up with another question about their particular situation, that they are on F1 STEM OPT right now and currently working at a company, and will they be able to travel? So what I could gather from what you responded is, if you have a valid stamped visa, you should be able to travel without any problems.
Exactly. That's what's going on right now.
Perfect. Another question right from Instagram is, Raksha asked, if H1B extension is approved and one should get it stamped from their own home country, then will the $100,000 fee be charged? Thanks in advance.
I have to find the language, but I was just looking at, they said that this was not going to apply to extensions, which I thought that was quite interesting. It's applying to new petitions. So
got it. So
yeah,
got it. Makes sense. Another question is from Ekagra is, do you believe it would have the impact on employers and there would be much less international students hiring, even if the fee doesn't apply to F1 to H1B?
I think it's already gonna have a massive detrimental effect to the F1 students, to universities that have F1 students, because as most of your audience knows, that the OPT, STEM OPT, is really a period to allow people who want to stay here in the United States, who've done to attempt to apply for the lottery and to see if they're counted. So I think that this will damper demand for international students here in the U.S. That maybe students abroad will think twice about the necessity of studying in the United States, and maybe we'll look towards Canada, Australia, other countries. It's going to have even if the law is struck down, it's already going to have an effect on the amount of F1 students. I think it will taper demand.
Got it. But let's look at it from the other way around. If the people coming in, like people outside of the US, if they are charged $100,000 fee even just to apply for the H1B visa, would that mean that companies would prefer hiring international students if this fee were to not apply?
Well, yes, I think if the way it works is if you are here in the United States already on a valid status, this fee would not take into effect unless you traveled outside the US and got your stamping and then try to enter. I think that in that regard, H1, the lottery selections for people who are here in the US, the chances are better, probably. Yeah.
Yeah, no, that completely makes sense. And can you also dive in a little bit about the current process that companies use to issue H-1B for people having change of status? And this particular person is working in a startup there, which is willing to sponsor them, but
Mhm.
they are not sure of the process since it is the first time for the startup itself to go through this process.
Well, the H-1B, just if when you file for an H-1B, the main question is whether the job offered by the petitioning employer is a specialty occupation, meaning one that requires a college degree or more in an area of study. You show that the candidate has a degree, and the job offered requires that degree to perform its functions. The change of status, when you actually file the case, the I-129 petition, there is a box on the I-129 petition. You can do consular process or you can do change of status, depending on where the person is. It's just you check off the box. And for OPT, there's something called cap gap extension that allows, like a lot of student programs will end right at the in like June. They have an extension so that you can keep on working until the October start, and then you can just seamlessly switch to H1B.
Got it. So for viewers who are just joining in, I see a lot of questions being asked around F1 students transferring their status to H1B. This has already been asked and answered multiple times, but just to give you a summary again, if according to the current wording of the proclamation, if you're changing your status from F1 OPT or STEM OPT to H1B, you should be okay and your employer would not have to pay $100,000 fee unless you decide to go back to your home country for your stamping, at which point they would be required to pay the $100,000 fee. But we will have to wait and watch out if this has some sort of injunctions played out in federal court or not.
That's right. That's right.
Perfect. And we just have a follow-up question on the same H-1B process. How much does it currently cost companies to sponsor H-1B visas, including legal fees, documentations, and what would the new cost be if we take into account the $100,000?
Oh, okay. Well, to sponsor an H-1B petition, the company, if they use a lawyer like myself, I usually charge, it's maybe $2,000 to $3,000, $2,000 to $5,000 per petition, depending on the complexity. And then in terms of the filing fees, it's there's a $1,500 fraud prevention fee, depending on the size of the company. There's another $700 fee for it's like a competitiveness things. There's about roughly around $2,000 in required fees. And then if you want to use premium processing, there's $2,805 to the US government. I actually have to look up the fees every time I do the case because it's confusing. But it depends on the size of your company too. And if they're also like a willful H-1B violator, there's also another fee. It varies.
Got it. And if the new proclamation were to hold through, the every kind of fee like would be a sum total addition of $100,000 on top of the current fees.
That's right.
Approximately.
And it's important to note right now, today, there is no instructions on how we actually pay this $100,000 fee. So, or whatever it is, this amount. So like on my end, I prepare H-1B petitions. I have no idea who to send this, who to direct the employer to send this money to, how to accept this money. I would never do that until they give it clear instructions.
Yeah, they just mentioned that you need to pay this fee, but they didn't really say how to pay this fee, where to pay this
Oh,
fee,
they didn't.
what to do. Yeah.
No idea.
Got it. There's another question from Instagram. We recently also heard news about the wage-based uh, idea of how much percentage of lottery is given to each wage level.
Yeah.
What would happen with that if this proclamation were to be signed, or are they mutually exclusive?
No, this proclamation, they assume that this proclamation will be going in conjunction with their new proposed wage tier, lottery selection based on the highest wages. And so like they are assuming that that will go through. That is still in the rulemaking process. And there is a lot of potential challenges to that. I'm not so convinced that that will come into play for next year's lottery. We'll have to see. But the from what I can gather, they assumed that both of these will be in play, so that they would
Okay,
have the wage tier and this 100K as well.
got it. Another question from Instagram is, a proclamation is not the same as an executive order.
Yeah.
What happens next in the case of a proclamation? Does it go to Congress for approval? How does it work?
No, so we were looking this up actually because it's news to me in the sense that like in previous the difference between an executive order and a proclamation. A proclamation is directed at the public, while the executive order is directed at the government agencies, the U.S. government. It's instructed. This is how we're going to do it. In terms of the legal challenges, like a proclamation can be revoked by just like an executive order by the next president, even if this is all upheld in court. The next president of the United States could say, you know what, we want to get rid of these executive orders and these proclamations, and they can do it on the first day in office. That's exactly what happened with Biden in when the switch happened.
Got it.
Yeah, the Congress. There is no the way that the American law works. There is no like take an executive order and turn it to a law passed by Congress. There is no, Congress can, legislators in the Congress can propose this rule in the Congress and see if it will pass. I think that is exceedingly unlikely. Congress hasn't passed immigration based reform for really decades, actually. But
Got it.
yeah,
I think this next question is right up your alley, with how you deal with O1 and talent-based visas. If
yeah.
this proclamation persists, how practical is it not to go into the H1B application lottery and everything and try for a talent-based visa like O1 or EB category?
Well, that's exact. I handle a lot of O1s. And to tell you the truth, I think that a lot of H1B applicants would not meet the criteria for O1. However, I think that if you do seamlessly meet it, like you have publications, you have presentations, you've conducted peer review, you have evidence that you had a high salary, etc., that it would be to your interest to do an O1, and I expect this is going to have a massive increase in people who are applying for O1.
Got it.
To add to the previous discussion, Daniel, about the proclamation versus the executive order, I think it is also prudent to mention about how a proclamation comes within the plenary power as well as the statutory authority the president has. And in addition to it, this proclamation has been issued because of the national interest and for the national security part, which is why a lot of there have been a lot of questions and discussions in the legal world about it being upheld in the Supreme Court as it was before in the Trump versus Hawaii.
Right, exactly. I think that listeners should understand that the Trump administration, although I think that this was poorly drafted and I think that it is grandstanding in many ways, there is a firm legal basis for actions like this based on the INA 212F of the Immigration and Nationality Act. And this is, Trump's travel bans have been upheld before, and unfortunately, this is what that is here. So,
Got it. There's another question with a rule that was recently changed with regards to my H1B is filled this year, and I need to go for stamping in the upcoming days. Do I need to only go to my home country, which is India, or I
yes.
can go to any other country?
No, you must now go to your home country. That was prior to this this latest proclamation. It was about several weeks ago. The Department of State said that they are now requiring every single visa applicant to go to their home country. They cannot do third party consulates. They must go to their home country. So.
Got it. And there's a question like a person is like asking about why would the stamping trigger the $100,000 charge and not the change in status from F1 to H1B? Like, what is the difference between the two?
Okay, the difference
Right.
is the president's authority is greater with people who are outside of the United States. So if you are been lawfully admitted into the United States, the president doesn't have the authority to just say, "Hey, your status is now obsolete," or we're revoking your status unilaterally. Can't do that. They can say, "Hey, we no longer want new people, new admissions on this status. We think that there's a problem of fraud or whatever, and we no longer want from these." Previously, it was done by country. Now they're doing it by the immigration, the type of case, and it's the president has much more authority to say, "Hey, somebody cannot come here for national security, whatever reason they want." It's there in the law, but they do not have the authority to control the American people who are here. That's kind of the basis of it.
Got it. And how does the stamping process differ from renewals? Like a renewal of an H1B visa is what I could understand.
Well, okay, so there's a couple things that people have to understand. There's H1B status. Status is what you have here in the U.S., and then there is the H1B visa. The visa is an entry document into the U.S. It's like a key to enter, and the duration of the visa, they could have many things that are on the. Some countries have very only 90-day visas to enter the U.S., whereas the status for H1Bs is issued in 3-year increments. And so like that's kind of it's this dichotomy between status and visa that that's why it triggers when you leave the U.S. to come back.
Got it.
Yeah.
Perfect. Deshni wanted to add something. Yeah.
Yeah, Daniel, there were also a lot of questions about the petitions that have been approved as of now, and can they still go for stamping and all of that? I think
Yeah.
they all can because it has
They can go for stamping, and they will not be subject to this fee. That's the understanding right now.
right.
You should expect to go if you have a previously approved petition and you haven't gone back for your stamping, but you need to go now. You should be able to go without invoking this $100,000 fee.
Great. Yeah. Okay. So the next question is it even worth to study in the US in 2027, like coming on F1? What are your thoughts? Like, do you think there will be more legal challenges with regards to OPT, STEM OPT in the future, or do you not see that happening?
I think that it's actually STEM OPT is under threat. I was just listening to the director of USAS. He gave a speech about a month ago saying that they're looking at seeing if they can remove STEM OPT from the process, from the options available to students, and just return it back to the old STEM. I mean, the old OPT, which is in 1-year increments, 1-year things. It will take a long time to actually do that. It's something that might take years to remove it, but it's something that is on the radar. So, you ask me, I always am very expansive. I've met so many clients who have expanded their careers, their horizons from studying in the United States. I want to encourage this. I think it's good for American universities. It's good for the students to study in the U.S. But I think that the international students are now under attack here in the U.S. Through a lot of things, and so it's increasingly unpleasant to study in the U.S. What can I say? I don't like it. I am one of the many Americans who think this is a horrible approach. But the Trump administration has been attacking international students left and right. This is another attack on the whole process. It's so I would factor that into any study plans that the U.S. is a little bit less welcoming towards international students today than it was a couple of days ago.
Got it. You mentioned that it might take years to get rid of STEM OPT or remove that completely.
Right.
Why would it be so, and why can't it just be removed with an executive order?
Okay, so the wonderful thing about STEM OPT is that it's enshrined in the regulations, and the Trump administration can't just take regulations that was passed by the agency USCIS and delete them and at the will. There's a process. They must follow the process, and that process requires to propose new legislation. They have to explain why they're doing this. What's the problem? They have to explain. They have to give the public a chance for notice and comment to give their input on this proposed rule change. So you can imagine that process is very, very technical. There is all these periods where they have to wait, and they have to draft legislation in a legal way. They have to give everybody, all these parties, the opportunity to respond. And if they violated any one of these steps, it can foil the proposed rulemaking. And so, just to give you an example, in Trump administration 1, they were talking about getting rid of work authorization for H4s who have a spouse that has an approved I-140. And they proposed that pretty close to the beginning of the administration, and they could not finish the rule by the end of the administration to get rid of the work authorization. It was challenged in court. They had to go through all this process, and they made a lot of mistakes, and it never came into fruition. So, that's one of the bases for it.
Yeah. Now this one is a very good segue because we're just talking about H4. I have a valid H1-B petition, but it was never activated. But now I am in the US with H4, and now I want to change my status from H4 to H1-B. How can I do that?
Well, I'm not sure if this was like a 2025 lottery selection. There's still, I mean, like, if the employer still has the job is still there, I guess you could, try to, show that it's still out there, this job, and then go on that. But if you wanted to go, in order to, I'm not actually sure exactly when the period is from when the lottery, when you're selected, to the max period when you could apply, continue with that selection. But, I would say, it is very common for people who are selected in the lottery, and then they wait 6 months before they initiate H1-B status. And you initiate H1-B status by actually working for the petitioning entity that, file that petition. So the first day you work, that you're on H1-B status. That's when it happens. So I've had many people who were like, hey, I was selected, but my employer just didn't, they were like, whatever. And then they didn't go through with the getting the petition approved, or like something happened, the applicant returned home before he get his, H1-B. And at that point, they're out of luck, like it's kind of, they have to go to the lottery again.
To add to it, Daniel, based on the language of the proclamation, I think that's what we are dependent on right now. This should not be a problem because there is already an existing H1B petition before September 21st, 2025.
Right.
But maybe there can be a question about, why are you changing it from H4 to H1B? The issues that we face that, for example, you're coming back from your home country, you're entering into the United States. And at that point of time, this question might come up as to why the change of status right now. Then the officers might be just confused about because
Well,
you jumped into the H1B status right now, even though the language does say that if the petition is approved, it is all good.
I think
So
that like it really depends on how long ago that I don't actually know. It was never activated. What that actually means. Like I assume that it means that like the H1B employer never worked for the petitioning employer to this point. Can they depending on what lottery, like how long can they wait? I mean, you have to show that the job is still there.
Yeah,
Yeah.
got it. Um, so Rajesh, if you're still listening to us, please make sure to mention how long ago was your H1B petition and when was it valid, and since when have you not activated it? The next question is, my friend was picked in this year's H1B lottery and received a I-797 approval, but was laid off before October 1st, the start date. Can a new employer still transfer that petition?
No, unfortunately not. You have to work for the original petitioning entity for a day or longer, and you can't transfer. Like if you were laid off before you were able to initiate that petition, to work on that petition, you're out of luck.
And
I
there's a
think it
follow-up
is
to this. Uh, there's a follow-up to this, and if not, he has to go back to the lottery in 2026.
That's right.
Would the $100,000 cap still apply to him, even though he had a I-797A?
Yeah, it should apply. My reading of it. Eventually, yeah.
I think it is essential for the audience to understand that just being picked up in the lottery and just having a petition approved does not itself satisfies that you are in the H1B status.
Right.
You have your name picked up in the lottery. You file your petition. If even if the petition is approved, to actually be in the H1B status by this is what it means to that you activated your H1B. It is essential for you to work with that particular employer at least for the minimum for a day, so that you can say that okay, this H1B status was actually activated. Only then you would be counted that okay, you have had an H1B visa. Then maybe you transfer to a different employer and all of that would be just smooth. But it is essential to understand that just does not end if you have an H1B petition approved. It has to actually be activated to get the benefit of it.
Exactly right, Deshla. Exactly right.
Got it. I think there's a follow-up question from a person who asked a question earlier about why would the $100,000 charge be applied only when stamping happens? And the question goes as very confused about the language of the new petition filed from outside the US quote marks. Since the petition would still be from inside, is stamping considered a part of the petition and why
No,
wouldn't it apply?
stamping is not considered part of the petition. There's actually people who never go back home. Once they're in like an F1 set. I've had clients all the time who have maybe they got an F1 and then they're on H1B and they haven't gone home for 10 plus years. It's this dichotomy in immigration law between getting these entry document, the visa, and having a status here in the United States, which the status in the United States is determined by USCIS. They have jurisdiction over that. It's part of the Department of Homeland Security. And the visa issuance in these entry documents is administered by the Department of State, which is a completely different agency and, part of the US government.
Got it. So there are two very similar questions, one from Greg and one from Pavan. The question is, I got selected in the H1B lottery this year and got my application approved alongside the change of status from OPT to H1B. I have my stamping in my home country, Portugal. Would I have any issues coming back? And I think the question is, would their employers need to pay $100,000 fee?
No, I don't think for this lottery, in this upcoming October, no, it's fine. Everything, it should be okay.
Okay, so the thing is, if you got picked in the 2025 lottery, and if you're going back to your home country for stamping, you do not need to pay for or you or your employer do not need to pay the $100,000 fee that was just added.
Exactly.
Perfect. So next up, I see a lot of questions about F1 and OPT. I'm just going to pop up one of those and just reiterate what has already been discussed. So if you are currently on your F1 visa or doing your OPT, STEM OPT, whatever, if you change your status from that to H1B and you stay within the US, you or your employer do not need to pay a $100,000 fee. But if you decide to go home for your stamping, your employer might have to pay the $100,000 fee as per the proclamation that it is currently written. There
That's
might be
right.
changes in the upcoming week, but we would have to wait and watch.
That's right. And there's also discussions about national interest exceptions. They have not outlined that process for employers that are have an H-1B petition that are exempt because it's somehow in the national interest. They did not explain. They did not explain that that exemption at all. So we're still in the dark on how that actually works too. So there's a lot of things that need to be ironed out before any of this stuff ever. Things. No employers have been paying the 100K. It's too new. No employers have been paying the 100K right now.
So just to summarize who this is particularly affecting is if you are a person working in Y country, which is not the US. For example, you're working in Germany right now for X company, and that company has an office in the US, and they are willing to transfer you internally by filing H1B. This new petition is considered as filed from outside the US for aliens, and then you would be like the employer would be applicable to pay a $100,000 fee.
In that scenario, what I would, this is something I really wanted to mention before, is that, there's also a lot of other options for, for skilled workers to come into the United States. And one of the best options is an L1 visa. So if you had a company that has offices abroad and you're a manager and executive and you're managing a team of professionals, if you were working for that office abroad, you could come for a year or more. You could come on L1 and then enter on L1, and there's no minimum wage requirement. There's no cap. There's none of that stuff. And I predict that a lot of companies will be doing that. They will have offices abroad and bring people on L1s here into the US instead of using H1B. It's already been happening, and though it's, I think this will accelerate that process. This whole thing will accelerate outsourcing from the United States, and also having international offices. With the outsourcing, you could transfer people back over here if they needed.
Do you think the intended benefit of this particular rule of making America first and American workers first would actually be of fruition?
Well, I think that I think it's kind of actually really silly, because there's other categories in the immigration system like TNs, L1s, O1As, where there is none of the there's none of the wage requirements. There's no cap. There's no things. I actually do not understand why H1B has been captured in the American imagination as a visa category of abuse. I actually think that other categories have as many problems or more for this. And it's just odd to me, that H1B has somehow triggered the imagination of the American public, and it's got the officials in the Trump administration all riled up, and they're picking on this one program when it's really a small sliver of the immigration to the United States. All of this stuff is way smaller than the family cases that are admitted every year, and then also border crossings too. Like that. Yeah. It's just a very, very small number compared to these massive numbers for the other. Yeah.
There are hundreds of thousands of people entering the US through borders, maybe illegally, legally, we never know.
Yeah,
But
exactly.
H1B is just 80,000 a year capped, plus a little bit of cap exempt on top of that, and they're making a big deal out of it.
I mean, it's I saw a commentator online. He said this is like the Indian Exclusion Act, and I actually think that that's true. That it's 70% of the people are on H1B are of Indian origin, and
Right.
I think when they're doing this, they're targeting. I hate to say it that way. I believe strongly. That in the power the benefit to the United States of Indian immigration and keeping these channels open, but the reality is that like this seems to be targeted to that. It's what can I say? It's really it's
Yeah. So, guys, we'll be taking two more questions. Just to summarize, before taking those two questions of what has already happened, what has already been discussed. Multiple things. First, if you're on F1 OPT or changing your status within the United States from visa A to H1B, you will not be liable to pay or your employer would not be liable to pay the $100,000 fee unless you go out for stamping. In that case, they might be liable to pay the $100,000 fee depending on how it plays out over the next week. Currently, we don't have any clear directions on how employers are even supposed to pay for it. Second thing, if your petition was already picked in the lottery and if you're already approved for it, you can travel for stamping without any issues. Or if you already have a valid H1 visa or any kind of valid visa, you can travel to the United States without any issues. Just carry your required documents that you are supposed to, and you should be good.
right.
Perfect. So the next question is by Suyash. What are the chances that the court will put an injunction on this, and how long does that process actually take?
Well, I think that judging from other lawyers online, I'm not involved in the litigation on this, but I think that it is quite likely that this will be successfully challenged in court based on past, some of the executive orders. Now, I do think that I personally believe that the $100,000 fee is illegal, as the Immigration Nationality Act specifically says that USCIS must determine the fees that are appropriate for these petitions based on how long it takes to adjudicate, how much effort they must have. It is not the authority of the President of the United States. And so I think that the challenge to this, there's ample grounds to challenge this, and I'm hopeful. I am a little bit disturbed that because it's relying on 212F of the INA, that which is held in the Supreme Court in past instances with a travel ban, that maybe it won't be as a wide ranging to be struck down as in maybe I would hope, but we'll have to see on that. I think it will take some time to percolate in the system, but fear not, there is a lot of people who have stakes in this, a lot of major corporations, universities, big institutions that matter, and they're thinking about this right now. This is going to hurt them big time. It's not just hurting the individuals, it's hurting those companies, it's hurting those universities, and they are very interested in making sure that this does not come into play, does not come into fruition. So they are going to work hard to get this overturned. So I think that the chances, with those type of big stakeholders there, it's even better.
Got it. Another question, which I saw a couple more of this exact question. What is the impact on already filed H1 petitions, change of status from F1 to H1 in July, but it has not been approved yet?
Oh, that's fine. You're okay. You can, like you have to get that petition approved. But if it's approved, it was filed well before this was enacted. Yesterday, and so that you just have to get that a petition approved, and then you're with everybody else who's here in the U.S. with approved petitions.
Got it.
Yeah.
So essentially, before they travel back to their home country for the stamping, they need to get their petition approved.
Mm. Some there's many holes already in this proclamation of parties that are not counted at all. As I think I mentioned before, there's thousands and thousands of cap exempt employers here in the U.S., such as like major universities, university hospital systems, etc. And we do not know. They seem to be included in this. And, we are, I was expecting that they would be a carve out for cap exempt employers, but there is no such carve out. Similarly, just today, the Trump administration announced that this would not apply to doctors. That's not in the original proclamations text at all. And, they seem to be becoming aware of all these big stakeholders and very critical people who have the positions today or something. Like, they didn't think about this when they drafted this. So
Yeah, with Daniel, I think the language of FAQ does mentions about the H1B renewals, like that they are exempted, but it
yeah,
nowhere talks about the cap exempt as well as the change of status. I think two of the
right.
major ways for an H1B petitions, as we have been discussing, that there are probably everybody keeps on filing the cap exempt H1B all throughout the years. I mean, the
Yeah.
lottery system and the lottery petitions do get only filed from June to October, but the cap exempt are just filed all throughout the years. And there is
Yes.
no language in the FAQ nor in the proclamation talking about what happens to the cap exempt. When you mentioned about the doctors, I think they just somewhere in the news also they mentioned that it might be exempted for the health providers. Now health providers and doctors, like they're like two different. There are so many people that come under the umbrella of healthcare providers, so it's
Yeah.
just silent on a lot of stuff.
Like for example, like the national interest exception during COVID, they often covered healthcare providers. It was extremely expansive. So I remember that like an IT director for the university hospital system had nothing to do with health, but he was considered a critical healthcare worker because
Yeah,
without his IT system, we couldn't use the computers. So
yeah, exactly.
yeah.
Yeah, so
It
there's
is
a lot of
also interesting.
uncertainty.
Yeah, and it is also interesting to look at how will they interpret national interest for the H1B with the 100K exemptions when they are already being so strict on the national interest waivers that we see.
Right.
When it is already strict on that, you don't know where will they narrow it down when it comes to the exceptions for the 100K fees for the H1B.
Yeah, we have
Yep.
no idea. It is important for the listeners to understand that the national interest waiver and the national interest exception are not the same thing. And I expect the Trump administration will issue guidance on the national interest exception for this new proclamation. We'll
Yep.
have to see what that's going to be like.
Got it. Just one last question I had from my side because I'm in a very similar boat. We have been talking about throughout this conversation that change of status would be exempt while you are in the United States since you're not an alien outside the United States. But
Mhm.
this is not the same language that is on the White House document. The White House document does not mention anything for aliens outside the US. So, how do you interpret that?
It doesn't mention it for aliens. It's
For the aliens inside of the US.
Oh, it
Yeah,
does not mention for aliens in the U.S., and that's done deliberately because the Trump administration understands that they do not have authority to just issue a proclamation affecting the status of individuals here in the U.S. The Immigration Nationality Act was passed by Congress. Congress has the ultimate authority on choosing, designing this system, the U.S. immigration system, and they passed the bill, and this has all been through the legislative process. So this ban, it's awkward because it doesn't. Trump is trying to get rid of unilaterally circumvent Congress and just get rid of the H1B program through an excessively high fee, but he doesn't have the legal authority to do that. So he uses this mechanism, this awkward mechanism of a proclamation.
got
H1B will
it.
still be there in the law, even if nobody uses it. Even if this is all upheld, it'll
Yeah.
still be the law. Like he didn't remove it from the INA, and he doesn't have that authority to do that.
Got it. Well, thank you so much, Daniel, Deshna. Thank you. I would just like to clarify to the viewers and listeners everywhere that this was just purely an informational session that we did. This is not a attorney-client privilege, or it does not bound you with any of the information given in this. But if you would like a consultation with Daniel's team one-on-one to understand your particular case in detail on how you can potentially go towards talent-based visas like O1, apply for EB1 categories and whatnot, do feel free to reach out. I will put all of their links in the description, or you can just search up Larson Legal on Google and you would have their result on the top.
Thank you, Juggle. It's been a pleasure, and I just want to, in this stressful time, I just want to wish your audience the best in this time. We're all getting through this, and hopefully, down the road to believe in yourself, and that these days, this tough period will pass.
Yeah, and then with so many interpretations of this proclamations and in this moment of extreme sensitivity, just please be calm and focus that you just trust on accurate and reliable news. It is very
Right.
important. This weekend has really been stressful for everybody. We have seen attorneys, law offices helping and translating and just interpreting it about how it's happening, updating you all on the news, the tweets that we see. But as a law office, like, we are also trying to digest everything that's been happening. We completely understand what's going on in everybody's mind right now, but it is very important to stay focused and just trust on the
And trust
accurate news.
in real accurate information, from official government channels. There's a lot of
Yep.
rumors out there and a lot of misinformation, and just be vigilant about that, and try to stay calm. And
Yep.
yeah.
Yep.
So the only two sources of information that you should be having is either any official documentation from the government or you talking one-on-one with an attorney and asking them for information, because you
Right.
should not trust any of the rumors outside of that. And all of this, as discussed multiple times, will change over the coming weeks. We will know more about it. And I'm in the same boat as you guys. I am currently on my OPT, as I've said multiple times. I might also be transitioning to some other form of visa to continue working in the US. So we are going to do this together and get through it. But yeah.
Yeah, as they always say, that every case is different. So don't just like panic with the one information that you read. Your case might be completely different, even if it somewhat matches the scenario. But that one tiny detail for your particular case might just either carve you out of it altogether. So don't
Yeah.
just panic because you feel that, okay, I fall under this broad umbrella of whatever's being discussed. Just be very mindful of that.
Yep. Well, again, thank you so much, guys. Thank you everyone for
Thank you
joining,
so much.
listening in, and
Thank you
asking
so much.
questions. I'll put down all the links in the description. Feel free to check it out or just search Larson Legal on Google.
Thank you.
And yeah, we'll see you guys next time, in the coming weeks that we'll do this again.
Okay.
Sure.